long before the indictment passed. Their pursuit was indeed relentless. The search was relentless. Dogs, divers, National Guard planes with infrared devices, cameras set up in 2014 somewhere in the woods near Cal's house, hoping to see him do something. I don't know what. They went into every well they could find, not only on Cal's property, but on the property surrounding him. Dropped down cameras. And they have no more proof than they had on September 15th of 2001. If insanity is measured by the repeating the same conduct over and over and over again and expecting a different result, what can we say about the state police who have never stopped harassing, investigating, searching, provoking Cal, and hoping for some evidence to come from it, and never having it happen? They have not found Michele Harris, and they have not solved this case because they've been investigating the wrong man, and they've been looking in the wrong area. Now, while their rush to judgment was quick, the gathering of evidence came slow, very slow. But the truth has finally began to peek its head at this trial. We finally begin to see at least an outline of who is actually responsible for Michele Harris's demise. And of course, that person is the person she was arguing with at the end of her driveway at about 6 o'clock in the morning on the September 12th of 2001. What did the prosecution and the police do after years of searching, harassing, provoking Cal, getting no evidence? They began to manufacture it with the help of cooperative witnesses. Thayer first asserted she made the phone call at 7:15 in 2004. The hairdresser, Wachinski, first reported death threats to Mulvey in 2005. The Turners now assert that Cal made a statement about a bread loaf-sized spot of blood not on September 14th, but in November, as Tom told the police in March of 2002. But now it is, he said it on September 14th. And of course, the photographs of the staining in the Harris home had to be corrected, or as District Attorney Keene said, altered. And now, 15 years after Michele has disappeared, they finally found a bloodstain pattern analyst willing to say that in his opinion, the blood on the carpet, the alcove, and in the garage floor were all from one incident. The evidence, as we'll go through it, shows quite the contrary. And in fact, the witness, when confronted on cross-examination about it, even acknowledged his own error. Notice how the witness testimony doesn't change randomly over time. Memories don't fade. They improve. They all get better. And they get better in a specific way. They get better for the prosecution and worse for Cal. That's not an accident. That's not a mistake. That's not random. Their proof in this case, Judge, is lacking, even in the light most favorable to them. But of course, as the trier of fact, you're not relegated to looking at the evidence in the light most favorable to the prosecution. You're free to examine it and scrutinize it and look at it to see if it makes sense. And of course, it's all about the staining, or the blood, as the prosecutor would put it. Unless they can establish that all of this staining in the alcove, on the rug, and on the garage floor was Michele's blood, that it was all deposited on September 12th, that it was a result of a violent attack resulting in Michele's death, having never even proven that she made it to her home. No proof that she ended up there. They have to prove that there was much more blood than they observed or collected, because of course our common sense tells us that there is no way on earth that a violent assault resulting in a murder yielded this much blood. And the testimony is, undisputed testimony is, that the blood they collected, or the stains they collected, even if it was all Michele's blood, and it clearly is not, 10 drops fits in this vial in 209. And of course, they have to prove that Cal cleaned up this blood on the early morning hours of 9/12. In short, for the prosecution, it's all about the staining. If they can't prove they've alleged here, the case should end. I want to talk briefly about the science. And I know that Your Honor paid close attention to that, so I'm going to go through it, I hope, quickly. They used 3 types of tests. Presumptive tests for blood, 2 of those, leukomalachite green and fluorescein. Confirmatory tests, crossover electrophoresis that confirms the presence of blood, and secondarily and importantly confirms that it's human blood. Lastly, they used STR or DNA testing. It should be important to recall that looking at a stain is insufficient to determine whether or not it's blood. And we know that, can I have this? We know that from the rub and from other areas as well, where we have stains literally within centimeters of each other. 1 being positive, or 2 being positive, and 2 being negative. These stains look identical to the naked eye. 1, however, didn't even test presumptively positive for blood. The other ones tested presumptively positive. But we also know that presumptive tests for blood, leukomalachite green and fluorescein, are insufficient to determine whether or not blood exists, because we have area 7, and I'm displaying, I don't know if Your Honor wants me to make a record of this, but D15, defense 15, which is a spot in area 7, and you can barely see it there, but it's right there. And if you look at the photograph, it looks identical, or nearly identical, to the spot in area 2. Now, area 2 tested presumptively positive for blood, and DNA tests were conducted in area 2. So after they do the presumptive tests for blood, they still can't establish that it's blood without the crossover electrophoresis, and they still can't establish that the blood belonged to Michele without DNA testing. Stains looking alike, being close to each other, even presumptively being tested positive for blood, do not equal blood. And they certainly do not equal Michele's blood. Now, the DNA tests don't test blood. What they test and what they get is nucleated cells. Nucleated cells are what have DNA. And nucleated cells are contained not in red blood cells, but in other fluids within the blood, and on skin, on saliva, and other bodily fluids. They can't tell us, when they do the DNA testing, where the DNA came from. They can't tell you, and each DNA expert said this, we can't tell you if it came from the stain or from cells, nucleated cells that were on top of the stain. What they tried to argue is that because all of the staining or all the DNA tests were single source, as they put it, that therefore it had to have been not skin cells, but from the staining. But the matrix that they used was set at a particular calibration. So New York State Police set their calibration for 100 relative fluorescent units. Other labs do less, 80 or 60. Some do more, 120. And what that does is when you're looking at the peaks on the electropherograms, and they look at a peak and they say, aha, that's the beginning of a profile, for the state police it has to be over 100. The ones just less than 100 could have been other DNA profiles, but they simply discounted it. And they're the ones who set the matrix. The other tests were available to them, but they did not use. For example, the confirmatory tests for blood and for human blood was only used on a handful of particular stains. There was an amylase test that could tell us whether or not the staining came from a cough or a sneeze, expirated blood. They didn't test any of the staining for that, any of it. They could have examined the DNA under a microscope and determined whether or not the DNA came from stains or from skin cells. They did not do that. So they have not proven where the DNA profiles came from with respect to the stains. And most importantly, we have that rug that was bunched up together, packaged in a box, unprotected, so that DNA cells or nucleated cells from one area of the rug could easily be moved to another area of the rug. What they're supposed to do in that instance to determine whether or not the DNA is coming from the staining as opposed to simply cells on the rug is they're supposed to do what's called a substrate control test. Take an area of the rug, cut it out, look at it, and determine if there's DNA on that. If there's DNA on that and there's no stain, then you're not sure if the DNA is coming from the staining or from the substrate, the carpet itself. They cut out the substrate control, Brown did, but when he passed it up to the DNA analysts, they never bothered to test it. So we don't know, and the prosecution can't prove, that the DNA tests on the rug came from the stains as opposed to the substrate itself. And what does this leave us? For all of the staining, they did, let me back up for 1 second. Each of the DNA experts who testified said to know that the blood comes from, or the DNA profile came from the stains, and that it was blood, you needed to do 3 tests. The presumptive test for blood, the confirmatory test showing that it is in fact blood and that it's human blood, and lastly the DNA test on the same stain. They only did those 3 tests on 3 areas. One was area 5. Area 5, presumptive test for blood, confirmatory test that it was blood, confirmatory test that it was human blood, a DNA profile that was consistent with Michele Harris, but also consistent or not inconsistent with the Harris children. So for area 5, they can't tell us whether or not that is Michele's blood, even if they can tell us it is human blood and there's a DNA profile for it. In area A, in the garage, they did all 3 tests. But what they did was they took 2 swabs. One swab they submitted, and that was tested confirmatory for blood. The second swab, presumptively positive for blood, they sent on to the DNA lab. So they did all 3 tests in that area, but not of the same material. One cotton swab was tested for 2 things. Presumptive test for blood, confirmatory that it was blood, confirmatory it was human. Another swab, 2 things. Presumptive test for blood and DNA results. No doubt the prosecution will argue that because these stains are so close together, they must be the same thing. But I've already demonstrated that's not true. You don't know that. You haven't proven that beyond a reasonable doubt. You can't. The carpet itself proves that. And you know what else proves it? There were hundreds of other stains that they tested presumptively for blood, never bothered to photograph, never bothered to collect, that were negative. The only ones that they collected were the ones that were presumptively positive for blood. So you have stains next to each other that look identical, but that are not identical. And we also know that in this particular area, we have an unknown male DNA in a bucket. We have two stains, numbers 2 and 5, that are not inconsistent. You can't exclude the children. And we have stains in area M that's not even human blood. So in this small area with maybe a total of 15 or 18 tests for DNA tests, you have multiple anomalies. You have non-human blood, you have an unknown male, and the unknown male, Cal was excluded from that. Could have been the children, couldn't have been Michele because it was a male, could have been the male children. And we also recall that Tanner cut his head and was taken to the hospital. And that Michele went back and cleaned up some of the blood that spilled from when Tanner, who was a toddler at 2 at the time, cut his head. So they haven't proven that all of this blood is Michele's. What they want to do, I forgot to set up these charts, sorry. Sorry. What they're trying to do here is say that every single stain we found in the garage floor was Michele's blood. And that's A through L, plus 2 other areas. The area next to, or between E and H, which is here, and an area next to D. But what they did DNA tests on is depicted on the white chart here, which is A, C, D, the area between E and H, and J. 6. They didn't do confirmatory tests for human blood on any of those, except for A, but they did it on the wrong swab. And it's important, I think, to notice how small, minute this staining is. Looking at the bigger photographs, it looks like there's a tremendous amount of blood. But when you get down really on your hands and knees and look at these are minuscule little droplets, often sub-millimeter droplets. So we don't have a representative sample of the staining here. We don't. And I would point out that the area next to D, presumptively positive for blood, they tested it. Here it is. This is one of these stained areas. It's hard to see on the overhead, but you can see it. There's a little bit of staining right there. And there's some staining that run through these lines. It's negative. It wasn't blood. It wasn't blood at all. I don't know what it was. Here's the area between E and H. The staining is right here and up in here, the darker shades. It looks identical to the area D, or next to D. And this tested positive, presumptively for blood, and I was a match to Michelle's DNA. So as we're looking at this, it's important to recall what they have proven and what they have not proven with respect to the blood or the staining. The one area where they actually did all three tests and did them correctly, and it came back to be Michelle's DNA, was the transfer stain on the rug. Area 5 came back to be inconclusive as to whether or not it was Michelle's blood. In Area A, they had different swabs that they tested for confirmatory for blood and for DNA. The transfer stain, all three tests were done, and it concluded that it was Michelle's DNA. But that was on the rug that was bunched together, and the rug outside of where Michele got changed in the laundry room, that she walked all over, and that particular stain was different than all the other stains. That was the only transfer stain. It was not another little dot. And so it's not clear that that was her blood, as opposed to just her DNA being on it because of the way the rug was packaged. We want to talk about the staining itself and what you can conclude through the, I'll put in quotes, the science of blood stain pattern analysis. First thing that we have to recall is, and I'm respectfully consider the quality of the investigation here. Not just, we spent a lot of time towards the end of the trial on the interviews, but consider how the evidence was documented and collected. I've already pointed out deficiencies in the scientific testing, in their method, not their methodology, but in what tests they performed and where. The next thing that I want to talk about is how the evidence or the staining was documented and collected. They altered every single stain that was depicted before they documented it. Not a single person or expert got up here and said, the right thing to do is take a wet cotton swab and rub it on a stain of a sub-millimeter size to determine whether or not it's presumptively positive for blood. Every single expert said, what you have to do is you have to take the photograph first and do the test second. And that would have done two things for us. It would have preserved the staining that they actually claim is blood, and we would have seen it in its original form, or at least in the form that the investigators first saw it, and it would have documented all the other stains that existed in the house that they thought was presumptively positive, they thought was blood from their naked eye, but turned out not to be. They did neither of those things. And a wet cotton swab, maybe rubbing on a big area, doesn't matter much. But rubbing on stains this size, Anderson said one area he picked up entirely. Ryan said that every single time he did it, he looked and he could see red staining on the cotton swab, so he know he received, he got it. So every single stain that they tested, they took some of the staining material off and put it on that swab, and then took photographs of it. And the photograph itself was deficient because when they took the photographs, the exposure was terrible in multiple instances where it was overexposed. We heard that from the photographic expert, Daniel Goodwin, who testified, and I think Anderson himself conceded that there were problems with the exposure, and you can actually see it with your naked eye. In addition, of course, we know that the photographs of the staining were 10 to 20 points to magenta, which is red. 10 to 20 points too red. So the documented evidence that they're providing to the court, and most importantly, to the other bloodstain pattern analysts who are going to look at it, are photographs taken after the stains were altered and taken in a way that didn't accurately depict their color or the exposure. Now, I don't know if it was on purpose that it was red, that what the testimony from Mulvey, that they, exposure corrected or keen, they altered the photographs, or it was just pure coincidence that they made those statements and it turns out that the photographs were too red. But they were too red. And the exposures were bad. And what Daniel Goodwin said is the exposure problems alters how dense the blood might look. That if it's overexposed, you're going to look at it and you're going to see, as I think he did in area J, you're going to see that it looks lighter than it may have actually been. And that one photograph that he took in area J, I believe it is People's 98, is a perfect example of what he was talking about. The overexposure below, where the exposure is clearly higher, the flash went off, it creates a lighter image on the inside. It brings out what's below it much greater. But where the exposure is not as bad, up top, it looks darker. And why is that critical? Because Labor and Laternus said that they, looking at the photographs, they judge whether or not it was diluted or not by this very appearance, which could have been altered by the exposure, and in this case clearly was. Laternus said no less than 11 times when he was asked, what's your opinion about this? He said, or what's your opinion? It's diluted, or it's this, or it's that. Mr. Klein asked him, what is your opinion based on? 11 times, 11, he said the color. The color is off by a significant margin. The exposure is wrong. You can't rely on that kind of evidence to convict a man of murder. They're arguing that the blood was cleaned up, and we know that because it was diluted. Their expert tells us that he's offering that opinion based upon photographs that we now know are not an accurate depiction of what was there. And you can see it with your own eyes. You don't even need the testimony. Goodwin explained why that looks darker at the top and lighter at the bottom. But you clearly can't look at it, or you clearly can look at it and determine for yourself, but we have expert testimony telling us why it is that way. When was the blood deposited? When? They have no idea. No idea. Every expert who came in and testified, theirs included, said, we can't tell. This is Laternus. This is the court asking Mr. Laternus, how long was the droplet there before it was altered? The witness, unable to determine, Your Honor. The court, could it have been a year? The witness, yes. A year. If the blood could have been there a year, we're done. This case is over as far as reasonable doubt with respect to Cal Harris. They have to prove that the blood was deposited on the 11th going into the 12th. If it could have been there a year, and their own experts both testified to that, Anderson and Laternus, they have essentially gutted their own case. They have admitted that they can't prove a necessary part of this beyond a reasonable doubt. We don't have to establish that the blood was there a year ago. Could have. A reasonable, plausible, just a reasonable hypothesis consistent with innocence is sufficient for an acquittal in a circumstantial case like this. We have a reasonable hypothesis consistent with innocence that the staining, or the blood, whatever it was there a year before Michele disappeared. When he said that, I almost stood up and said, can we go home now? Can Cal finally take his children home? Now, no doubt they'll try to argue, well, you know, there's other ways we can determine that it was not there for a year. And the answer is, not scientifically, not beyond a reasonable doubt. They may argue that Thayer washed the rug or cleaned the rug, but Thayer's testimony was that the rug, once every 6 weeks, she either shook it out with other rugs and washed it. And we learned from labor, and I think we learned from labor that if the blood dries on a fabric, after it's washed, it may still be visible, and you can still get DNA off of it. We don't know the last time that Thayer washed that rug. We have no idea. 6 weeks before this, she said she didn't work much over the summer. Who knows? There's no testimony about it. I know that Mr. Klein tried to argue that, well, this is a high-traveled area, so if the staining was here for a while, it would have been obliterated or removed. It is obliterated. It is removed to some degree. The staining along the garage all has signs of being altered in some fashion. Somebody walked through it. Some of it dried up and flaked off. Some of it looked like it was transfer stains. It could have been from a dog walking through different staining areas, walking there. A number of things could have happened for it. And the stains are so minute that to be able to have to step right on it, to obliterate it, would be nearly impossible. But all of these little teeny stains exist, and the only ones that were DNA, there's only 6 of them that were DNA positive for Michele. They look like they've been there for quite a while. They don't look like they're fresh in the sense that they are whole blood or neat or unaltered. They're all altered. The rug. The rug was recovered, and the way it existed when they recovered it was like this, looking at People's 51, with that blue streak on the left-hand side of the rug. The staining, as we know, is on the opposite side of the rug. We have a picture that was taken before September 11th. And we see the rug. Well, this is not going to work on the overhead, but you can look at the pictures itself. You can see that the rug is in the same position. In other words, the blood or the staining on the rug was face down when they recovered it. The same position it was in before September 11th. It had been there for God only knows how long. There's no proof that it was deposited on September 11th going into the 12th. None. Zero on the rug. Zero. And if they can't prove that the staining on the rug occurred on September 11th, they can't prove the rest of it. They don't know. And the only proof that we have seems to indicate that the rug was in that position, presumably with the staining on it, well before September 12th, when Michele disappeared. Now, did the staining come from a single event? Well, the answer to that is, of course, you can't tell one way or the other, but Laternus, based upon the DNA tests, with the hypothetical that Mr. Klein posed to him, said, yes, in his opinion, it would have all come from the same event. Well, if that were true, and the rug sometime before September 11th, well then, in some instance, or in some ways, that actually proves Cal's innocence. If Laternus is right about that all of the staining occurred when the staining on the rug occurred, and they can't prove that happened on September 11th, and we have photographs of the rug upside down well before the 11th, then the staining occurred then. But he's candidly not correct about that. You can't tell whether or not all the staining occurred at the same incident, which is another defect in their proof. I asked him the same hypothetical that Mr. Klein asked, Laternus that is. All I did is I asked him to assume some other facts that were actually from the case. Assume that there was DNA in a bucket from an unknown male, assume that one of the Harris children cut his head, and assume that blood was cleaned up. And I asked him, taking those facts into consideration, would that affect your view as to whether or not the staining in these three areas came from one or more, possibly more than one event? His answer, it would probably come from more than one event. So when he's given a hypothetical that includes all of the facts, he concedes what every other expert who's looked at this tells us. We can't tell. He actually went further and said it probably came from more than one event. When Mr. Klein stood up on redirect to try to rehabilitate him, all he did is go back to his direct testimony and said the DNA. If you just ask about the DNA and you just look at one segment of this, well, sure, I guess you can come to that conclusion. But that's not what we have. What we have is more facts than just the DNA tests. Are the stains consistent or inconsistent with a violent assault? A bludgeoning, which is what, in essence, they've alleged because of the transfer stain. And the answer is it's inconsistent. Can we play? There are some characteristics that exist for transfer stains. And they were demonstrated by Mr. Labor. And could you stop it right there? Now that's just a small amount of blood with a hammer dropping down on the blood and causing staining. What are the characteristics that exist for impact spatter? What are the characteristics that exist? Angled directional stains defying gravity is the first one. It goes up in a cone away from the blood source, or in a bludgeoning case, the victim. So what you will see is you will see blood going with a directionality heading, defying gravity, going up. You'll see multiple droplets of blood of all different sizes. You'll see evidence of active bleeding. You'll see globs of blood. You may see cut skin, broken bones, other cut hair, cast off, so that when the person is bringing the bludgeon down and then bringing it back, blood is going to fly up and back or away from where he's striking. You look for those kinds of things to determine whether or not it's impact spatter. And of course it has to be a pattern. It can't just be one stain, because one stain doesn't tell us anything at all. We know there's not enough blood for a bludgeoning. We know there's no upward directionality to any of the stains. We know there's no skin found, no bone fragments, no cut hair, no cast-off stains on the ceiling or behind cowl, which would have been the countertops and the walls and surrounding the counters. None of that exists. No pooling indicating active bleeding. No continuous pattern between the random stains. No staining at all. Critical. Absolutely critical. No staining at all on the linens, the white linens on the door, on the outside of the door to the laundry room. So you have this bathrobe, you have this fabric bag with these items. They can talk about cleanup all they want. You're not cleaning blood off of that. And remember what Labor said. a cone fashion. It goes up and around. If there was a beating in that small area, you would see staining all across this area, these doors, not a spot here or a spot there, and staining the laundry room doors right here to the right, and that's where the fabric is. And the rug, if it was there, and there was a violent assault that resulted in a death, wouldn't just be laid out perfectly where the stains would end up on. It would be crumpled, rolled up in a ball. There'd be blood and odd spots all over it because it slides. It's movable. There is no indication that this was impact spatter. Certainly not proof beyond a reasonable doubt that this was the result, or this staining resulted from a violent assault. The stains on the rug could have come from a sneeze over a cut lip, a cough with a bloody nose, or as Labor showed us, a single drop of blood hitting a shoe. To me, this is just incredible in the sense of what you end up seeing comparing it to the rug. Just incredible. Until I saw this, I never would have believed that a single drop of blood hitting a shoe would result in stains that have that kind of pattern. But it did. It looks like impact. It looks almost identical to what's on the rug. And all it was is two drops of blood hitting a shoe. And the transfer stain, Laternus said it was the size and shape of a pad of a Band-Aid. It's also the size and shape of a heel of a woman's shoe. You have no idea. We have no idea where it came from. And can we play the videos of the blood hitting the pants or the blood hitting blood? Until we had the slow or high definition photography, we didn't have any idea what could happen with these small drops of blood, which is why the profession of bloodstain pattern analysis has changed so much over the last few years. That's one drop of blood hitting another one, creating dozens, if not hundreds, of small stains. Show the one hitting the pants. I think he said this was a 60-degree angle. You end up with the same exact pattern. A flick of a finger, a cough, a single drop bouncing off a piece of fabric or off a shoe can cause the staining that exists there. And of course the rug is movable, so we have no idea where the rug was when the staining was deposited there. None. It could have been by the kitchen sink. It could have been in a different spot. Barbara Thayer said, thank you. Barbara Thayer said that she moved the rug from time to time. Didn't pay attention to where one rug, because there was another rug that was similar, in her view, identical, and didn't pay attention if they were going back to the same place. We just don't know. And we have to know if Cal is going to be convicted. Just give me an idea of the time. Is that clock bank? Okay. All right. Of course, the prosecution's going to argue cleanup. The blood, more blood, ignore the blood that they actually collected. Ignore the fact that all they found was this much in 209, because of course there was much more and it was cleaned up. Now, Laternus, on this point, was admonished by the person who's, I believe, a PhD, not to say that the blood in this case was cleaned up. Admonished. She did a peer review and said, you can't say that. It was altered, perhaps. It looks diluted from the photographs, but you can't say there was intentional cleanup. Oh, master's degree, sorry. And look, I'm not faulting Laternus for his education. He's obviously done well for himself. But he has a high school education. He was a police officer who ended up being trained by one person on bloodstain pattern analysis, and he's made a career of it. Good for him. But one of the things, and we brought this out through the testimony, that the National Academy of Sciences cautioned is be careful of bloodstain pattern analysts who don't have college or master's degrees in physics, mathematics, and other applied sciences. He has none of that. He tried to say there was, quote, evidence of cleanup, and what took place was the peer review person who looked at it, who has those kinds of degrees, said you can't do that. I'm not going to check off that this is correct. So he took it out of the report, got the authorization from the peer review, and then came in and said, who cares? I mean, he wasn't flippant about it, but that's essentially what he did, and said, I'm going to testify that it's cleanup anyway. What is the point of a peer review if when you get specific criticism on a critical point that you ignore it? Worse than ignoring it, it's not like he said, I understand your criticism, I'm going to stand by this, you write whatever minority report or whatever you want with this is my view. He took it out so he could get the report authorized or stamped or certified on a peer review, and then came in and testified to what he wanted to anyway, as if he never heard that. And then it's worth going through the cross-examination on this point, because for a while he's like, oh, she had no doubt that there was intentional cleanup, it just was, she didn't want to use the word or something like that, until we finally got down to it, where he finally ended up saying, yes, her view was, well, we ought not say that, because we had the notes, her emails to him. So on this critical point of whether or not there was cleanup, you have an expert with a high school education being admonished by the person who's reviewing his work not to call this intentional cleanup, ignoring that and doing it anyway. He also was told that you can't say that the DNA results came from the blood, because his peer review colleague understood that you can't say that. The DNA comes from nucleated cells, not blood. Nonetheless, again, he ignored that and testified to what he thought was best. Going beyond that, look for signs of cleanup. Were there blood in the drains? No. Were there rags or towels found with blood on them? No. The mop was tested. Each strand of the mop was tested. Each strand negative for blood. No odor of cleaning substances. And remember, Thayer was in the house first thing in the morning at 7:30 or so in the morning. The police were there only a few hours later. No fibers from a mop or a rag or a sponge found anywhere on the paint chips or on the floor that would have had to have been wiped. You're wiping a fabric over the course of over cement and paint chips. It's going to leave some trace. There's none there. No paint chips were found in any of the drains. None. They say that there are areas that were cleaned. We'll look at the photographs in a minute, but the areas that were supposedly cleaned had whole blood in them. And this is a critical to understanding this. Keep putting this away. Their claim is that there is some amount of blood in this center area where they say it looks clean. I would suggest to the court it doesn't look cleaner except for the exposure. It's brighter in the middle here and darker on the sides, But that's the exposure. That's not the how much dirt there is or isn't. And I'll show some other photographs in the video in a second to demonstrate that. But in here, in this area, is where supposedly the cleanup took place. And there's a couple of things I asked internists about. One is the paint, or the staining that was underneath the paint chips was in two directions. So it indicates which way the blood was, or the items were supposedly pushed under, up and down or east and west. And if you recall that testimony, he said, yeah, that's correct. The swiping was going east and west. And it said, okay, well then, where's the spatter or the cast off or the diluted blood east or west? It doesn't exist. The J, which looks to be diluted, but we can't tell for sure because of the exposure, is over here to the south, facing the area where the drain is. But that's not the most important thing. The most important thing is the blood here, in the area between E and H, is whole blood. Whole blood. How could they possibly say that he took a wet rag and wiped up this pool of blood so well that the cement has barely a trace of it in there, and that leaving whole blood under the paint chips? Labor told you that was impossible, that if that had occurred, the blood or the staining underneath the paint chips would have been diluted, heavily diluted, and common sense tells us that as well. The fact that there's whole blood in the middle of the area that they say was cleaned proves it wasn't clean. They did, I would suggest to the court that the ultimate test of whether or not there was intentional cleanup is, are there areas that test positive for human blood that look clean to the naked eye? People who commit crimes and try to clean up the blood do not have the wherewithal to understand the depths of the forensic sciences and tools available to investigators. So if you have a drop of blood that hits the floor and you take a tissue and you wipe it up and you look at it and you say that's clean, or even if you use water and wipe it up, you look at it and you say that's clean, investigators can come in with fluorescein or luminol, light it up, take a sample, take it back to the lab and say, you can't see the blood, but I know it was there. Well, they did that. They did that here. They took fluorescein of a number of areas, including this area, and they sent it back to the lab, and there was no blood on it. None. All of the fluorescein testing, all of the luminol testing showed no blood, no cleanup, no intentional cleanup. Certainly no cleanup that took place on September 11th or 12th. Laterna said he was trained by the one person who trained him to conduct experiments to prove that the method by which he thought the blood was deposited actually was deposited by that method. So he looks at a scene, talked about going back to his lab and saying, let me see if I can recreate this. That was his training throughout his career. Did he do that here? No. No, he did not. Because you could never recreate this scene with the method that he described. The angle of the spatter and the directionality in J is 20-something degrees. Labor told you it would be less than 5. Labor did, albeit not perfectly, at least he tried. Went back to his place, took real blood, and tried to recreate the scene. And what he tells us is, this is impossible. It didn't happen that way. Now, I know that he had a floor that was not painted, but what he was trying to do is, one, what happens when you wipe up blood on any surface? How do the patterns look like? And we have those photographs of that display with these kind of like, almost like a hand, with the lines, the very sharp angles going out at a bunch of different angles. That doesn't exist here. Over raw cement, which is what we have in the chipped out areas. Remember the area that they're saying was white.
It was right here where E and H exist, and over here by D. The exposed cement, porous, would absorb the blood. It would be almost impossible to get it out of it. And we saw pictures that Labor showed of what that looked like. And he said if you clean the blood so well to visibly remove the blood from the cement, you would dilute the stains under the chips significantly. So we don't have to prove how it happened. We don't have to disprove their case. They have to prove it, and they haven't. You had an expert that they called in from Canada, who has never before testified in the United States. This is his first opportunity, with a high school education, who contradicted his peer review examiner, who came in here and said, my career, I was taught to do these experiments to confirm my subjective belief, and I didn't do them here. They had an opportunity, or Laternis did, to try to prove that which he asserted. And despite his training, he did not do it. Now, the argument that Mr. Klein made to Labor said, I remember he read from Kish's book, saying that oftentimes intentional cleanup of a crime scene will leave diluted blood. And we saying you have diluted blood here, and he wants you to assume the opposite is true. But of course, that's not logical. It's a fallacy. A dog has 4 legs. There are 4 legs on the chair here. It does not make it a dog. The characteristic diluted blood didn't necessarily come from intentional cleanup. Just because that's a characteristic of cleanup doesn't mean that if you have diluted blood, it was cleaned up. Diluted blood can come from a number of different instances. There could be dampness on a garage floor. There could be water added before the blood was deposited, after the blood was deposited, or somebody could have cut their hand, washed out the cut, their hand still being wet, and the blood could have been deposited there. Also, you could have cut your hand in the snow and ice on March 19th of 2001, outside, held your hand, walked in, and then looked at it after you walked in for a moment or two, and it drips or it spatters because you've shaken it. And we know from Michele Harris's divorce papers that she cut her hand when Cal and her were fighting over her jackets the day after his mother died, March 19th, outside, and we have the weather reports, 4 inches of snow on the 18th and 19th. She cut her hand outside in the snow, wet hand, walks in, and we have the blood. Now, I don't know if that's how the blood got there or the staining got there, but it certainly is a reasonable hypothesis consistent with innocence. We know she had a Band-Aid on her leg on September 11th. We know she worked in a restaurant and early testified that she frequently had cuts and scrapes, which you'd expect. We know that women cut themselves shaving from time to time. We know that people bleed in their own homes. We know all of these things. None of these have been eliminated as a reasonable possibility. And I think the last thing almost the last thing I'll say about the cleaning, we know that Cal didn't intentionally clean up after the crime scene because had he, the rug would be gone. Wouldn't be there. Think about what they're suggesting. What they're suggesting is that on September 11th, September 12th, Cal killed Michele. That he saw blood, intentionally cleaned it up, and he had to have seen it on the rug, which is the area where they say she was attacked. Had to have seen it on the rug. He was right there. And we know that he had to have seen it because the rug was flipped over. Who would do that? Who would do that? The meticulous individual that they describe as Cal, who would look at blood on the rug and say, I missed this, what should I do with it?
Now, let me not put it in that secret place where they're never going to find Michele or the bloody rags or the clothing or the weapon or anything else. Let me not just throw it away. Let me not throw it in the wash. Let me flip it over and maybe they won't notice. And he had plenty of opportunity to do that. Thayer was there in the morning of the 12th. The police were there the morning of the 12th. He signed consent searches that they could come back with a forensic team to examine his house on the 14th. So he had the evening of the 12th, all day on the 13th, and the evening of the 13th. Now, would somebody say, hey, what happened to that rug? Maybe. Maybe somebody would ask him about the rug. Maybe Thayer would notice it missing. And he would be able to say, the dog soiled it. I don't know, it was gone for a while. Anything would be better than trying to explain Michele's blood on it. It didn't happen that way. It's not plausible that the man killed his wife on the rug and left the bloodstains there and just flipped it over. And we know that the rug was in that position before then, because we have photographs from it. We have this myth of one area being cleaner than the other. The exposure for some reason a little better up there. And all this comes down to is, look at that. You can almost do it here with the exposure I'm doing it. It looks dirtier at the top and cleaner at the bottom, but as you move it up, you can see there's different areas. Looking at the photograph here, what this is areas with heavily chipped paint and areas with not heavily chipped paint. Looking at the fence 41, it's a small photograph, but if they were interested in this, let me see if I can put it up here so it can be seen well. You look at this and you're saying, what about this area down here? Doesn't that look cleaner than the area around it? How about this area over here? How about in here? How about in here? How about up there? And actually the bigger photograph it shows it the same thing. It is unknowable which area was cleaner or not. And they say you can see it on the video. I'm not going to play the video because it's just too cumbersome to play that one segment. But I would ask the court, when you're reviewing the case, take a look at the video, and there's a shot from the doorway looking out. I asked labor about it, and in that area, what you'll see is a clear path that runs from where the car was to the doorway. And what happens is, people with wet boots, with shoes, the grime and dirt gets worn off, not built up in that area. It's not that that's going to be dirtier. That's actually going to be a path, similar to how it goes through the woods. And if you look at the photograph, if you look at the videotape, you'll see to the left, closer to the wall, looks cleaner. And actually, the path, if you will, continues beyond where the car is. It's simply the areas that were chipped less. You know, there was a statement made, the absence of something is not proof of its existence. And that's certainly true. The fact that they can't find traces of any more blood than what is in Defense Exhibit 209 does not mean that there had to have been more blood. It's not proof of it. Proof of it would have been rags, drains, paint chips in the drain, or the fluorescein test. And ultimately, Judge, could someone have spilled blood or bled in that area and it been cleaned up at some point in the past? Yeah, that probably happened with Michele Harris and Tanner. Shannon Taylor testified to just that. that when Tanner cut his head, Michele was concerned and went home and cleaned up. And we know at the bottom of that bucket, there is DNA from an unknown male in there. If somebody bleeds and they actually see what's there, they might very well bend down and clean up the spots that they see over some period of time. It does not prove a crime. It proves that somebody cut themselves and saw where they spilled some of the blood and cleaned up that what was obvious. And of course, remember when we talk about that DNA at the bottom of the bucket, it's also consistent with areas 2 and 5. And the prosecution doesn't have to prove motive, but in fact what they've alleged here is that there is a motive for Cal. They've alleged, and they alleged in their opening, that the divorce was, quote, heating up, that he was worried about a $30,000 fee to appraise his businesses, and that there was a trial date looming, that he thought Michele was rejecting an offer of settlement he had made, and that he did not want to lose control of his businesses, his wife, or his children. None of this, none of this turned out to be true. None of it. The motive, like much of the other evidence in this case, was put together by cherry-picking some facts, ignoring others, and glossing over the core of what actually took place. What we know is that, as matrimonials go, this was actually, when I say matrimonials, it's one of the great euphemisms of our profession, that if you practice matrimonial law, you're not performing marriages, but you're presiding over divorces. So this divorce case is not particularly bitter. It started off like many of them do. One person wants it, one person doesn't. A marriage has fallen apart. There was infidelity by both parties, and it starts off bitter, and it starts off with court fights. But 9 months later, the case was settled. It was over. Michele was accepting the offer that Cal's attorney had made. Cal had conveyed that to, Cal's lawyer had conveyed it to him, to Cal. They had resolved their differences. The fights, the acrimony that existed in the spring of 2001 had subsided. And that's a fact that was testified to by basically every single person the prosecutor called. Linda Hyatt, Barbara Thayer, Shannon Taylor, and Bowles' first name? Rhonda Bowl. All said that by the end of the summer that things had calmed down between Michele and Cal. Cal had accepted the fact they were getting divorced. He had moved on. He had made a substantial offer. Michele was taking it. There was Stan Drazen's testimony, who said, very detailed, corroborated by the correspondence. He made the offer on August 1st. August 6th, he sent out this letter, which is 203. No, 203 is not in. 202 is. Sorry. 202, responding to the negotiations, saying that he spoke to Cal, that the objection that Mr. Miller had raised about the adequacy of the life insurance had been addressed, and they had agreed to his terms, and they responded to this. This crossed in the mail with a second application that Mr. Miller made for the appraisal fees. But Mr. Miller had made that same application for appraisal fees only, or was denied only 45 days before that. June 8th, the court issued an order that said the remainder of the plaintiff's application, including those fees, is denied without prejudice to renew it after discovery has moved forward. After discovery has moved forward. Between that order, June 8th, I believe, and August 6th, discovery hadn't moved forward. Virtually nothing was done. No documents demand was made by either side, and really it's upon the plaintiff in this case, the unmoneyed spouse, who would issue document requests. No depositions had been conducted. There's no indication that the appraisal of the house had taken place. Nothing was done. There was no chance this application was going to be granted that was made August 6th, when he was just denied for the very reason the court wanted to have discovery move forward first. So Cal was not in fear of losing $30,000. He was not in fear that the trial was going to go forward. That proposition is ridiculous. The very motive that they've alleged it's simply insane. The trial, there was no note of issue filed, there was no discovery done. The appraisals that they wanted to have happen, and we have this is 129, we have the proposal for the $30,000 from this accounting firm. Look at it. It has hundreds of hours of work yet to be done. So on September 11th, there was hundreds of hours of work to be done for the appraisal that they wanted to have happen if the judge had ordered it that day, which of course he did not. The case was not going to trial. It was not ready for trial. There was no appraisal fees about to be ordered. Discovery hadn't been started. And we know why all this took place, because we know that the case was settled. Now, the one thing that did happen on June 25th is that Cal reserved a few things. The updated statement of net worth, which is standard, refund, income tax, refund checks, individual tax returns for 2 years, and royal tax returns, 3 volumes. But I want you to note something. The date he sent this to Miller was June 25th. It was originally filed with the court on, I believe that's January 30th. This was done well before Miller was involved. He simply reserved it on Miller. This was not discovery moving forward. This is just the first thing that you have to do. The rules of the court require filing the statement of net worth. Oh, let's say 2007. Sorry. How does that make sense? Anyway, it is, I actually still think that looks like 2001, but my colleagues may be right. It may be 2007. The point remains that it is the statement of net worth is the first thing that gets served. It's required by the rules of court. It's not discovery moving forward to the extent where that is likely to result in the order of the appraisal fees. And we know from Mr. Drazen that on September 5th, he and Mr. Miller had an extensive conversation that they reached an agreement in principle as to what was going to take place, and that the case was going to be resolved. As Miller said, I'll have her in next week to sign some kind of letter of intent or sign some kind of settlement. And we know that that's true because Michele had told her friends that she was indeed accepting the offer that Cal had made. So the idea that somehow this was heating up, the opposite is true. It wasn't heating up, it was literally calming down and ending. And you heard what Cal's reaction was when Drazen told him what had taken place. And what he had said was Cal was, quote, relieved. And that was only a few days before Michele's disappearance. There's an interesting part to this, which is what Cal supposedly told the police concerning the divorce. According to investigator Myers, Cal said to him he thought Michele was rejecting the offer. That was an odd thing for him to say or report about Cal, since what he wrote in his notes was that Cal had not heard back officially concerning the offer, i.e., he hadn't heard back officially. Nothing had been signed yet, which is exactly what Drazen told him. He did not write down in his notes that the offer was been rejected. And Young, who testified, didn't recall that at all, said that Cal said that the divorce was largely dormant at that point in time, that nothing was going on, that they weren't waiting for anything to happen, that the case was just existing at that point. We have the chart. The money, which I think is interesting. This is a chart that comes from the checks that were introduced. What? These are all the checks that are in evidence. There's a couple of figures I want to point to the court about. The court had ordered that Cal pay Michele $400 a week and made that retroactive to May 14th. What he had to pay her between May 14th and September 10th of 2001 is $7,200. What he actually paid her over that period of time was $8,434, $1,200 more than he was ordered to pay her. And what's interesting about how much he paid her is not just the amount, but the exact amounts. If you look at it, clearly what he was doing in June, $400, $800, $800, $800, $800, $400. $400 a week is what he had to pay. $800 was the payment for that week plus the payments for the retroactive money. And that continues all the way down to the end of August, when he begins to pay her odd amounts, $641, $782, $159, and including $521 on September 10th. What that indicates is that they were communicating. That Michele was saying, I need money for this. I need money for something else, for school supplies, for I want to do something for myself, or I need extra money. Can you give me this? And Cal was complying, indicating that in fact they were getting along, they were communicating, things had in fact calmed down, and Cal was paying her $1,200 more than he needs to. And recall, he never actually cut her off. If you go back and see the checks, the amount dropped off in March, April, and May. But he paid for the entire household, the maids that came over, everything that the kids needed, all the expenses. And during this time period when Michelle's getting all this money, she's still working at Lefty's. She never stopped. And she's getting $800 a week in spending money with absolutely no expenses. Her car is provided to her. Everything she has is provided to her. I think it's important to look at the chronology to some degree of what took place here, because it reveals something. Both parties ended up having extramarital affairs, following which Cal wanted to keep the marriage, to salvage the marriage for the sake of the children. And what his belief was, based upon what he said was research, was that divorce was bad. It was better for the kids to stay together, even if the parents weren't getting along. Michele met Brian early in November of 2000, Thanksgiving weekend. Almost immediately began an intense sexual relationship with him. Almost immediately. What followed were two things. Michele voluntarily moved out of the marital bedroom. Barbara Thayer told you that about 9 or 10 months before she disappeared, she chose to go down and start sleeping on the couch. It was not a coincidence that followed the commencement of her relationship with Brian early. And number two, she decided to file for divorce. Understandably, relatively young woman, had been married for 10 years, was raising 4 young children, in a marriage that had probably collapsed, said, enough, I want to get out. And she filed for divorce. But she didn't do it after discovering Cal's affair. She did it after starting one of her own. And I don't fault her for that. But it's important to keep the facts in perspective. That's what happened. And when she first told Cal that she wanted a divorce in December of 2000, he reacted angrily, bitterly, mad, screaming, yelling, lost control of himself. I don't think there's any doubt about it, if you listen to the testimony from Shannon Taylor. And what did he do? Did he attack her? Did he physically abuse her? Did he hit her? Did he assault her? Did he threaten her? He was screaming, hang up the phone. I want to talk to you. That is the incident. That's the incident of December 8th. Understandably, he overreacted. But it ended peacefully. It ended with Michele going back home that very night with no further incidents. The other incident where Cal reacted, I think, poorly was on March 19th when he took her coats. I mean, this is the childish stuff that goes on in divorces, sometimes for a while, but he took her coats and said to her, according to Michele, and we have her sworn affidavit in the family court records, when I asked him to return them, the coats, he refused, and the petitioner, Cal, said I could have them back when the respondent returned, Michele returned the guns. This is childish. This is insanity where you have, she took his guns, and he says, I want to take your coats. And they're fighting back and forth over it. Something happened where Michele fell or was pushed in the snow and cut her hand. Now, Cal's certainly not proud of that moment, but remember the date, March 19th, literally the day after his mother died. His wife is leaving him, his mother died, and he is upset. And what's his reaction to that? Take her coats? This is not a man who's plotting murder or contemplating murder. Did Cal go to various friends and relatives and ask for them to help talk Michele out of the divorce? Of course he did. I'm not sure what's wrong with that, but he said over and over again, I want to save the marriage. Would you help me do that? He went to the Taylors. He went to I think Linda Hyatt and a few other people he spoke to about trying to save the marriage. None of them were willing to or were able to help him. There was one report of a threat that Cal supposedly made by that Michele reported to supposedly to Mary Jo Harris, and that ended up being reported back to Cal. But think about it for a second. The threats and everything that Cal had supposedly done, all of that went before a Supreme Court judge in a divorce action asking for exclusive occupancy. This threat that Mary Jo reported to Cal never even made it into the application, let alone some finding that it was made and it meant something. It meant nothing, and it was in March of 2000. Judge, I've been going for about an hour and a half. I'd like to take a break in about 5 minutes, if that's okay.
How much longer do you anticipate going?
Hopefully only another hour or so. Okay. I want to finish up just one more thing before we do that. Wyszynski. It would be wrong to ignore the threats that he claims were made. What he said was that he received a phone call, in July, and that Cal had threatened to kill Michele and make her disappear if she didn't drop the divorce proceeding. We have his work records, or the work records for the place that he works, indicating that Michele's last time there was in May of 2001,
and that he said she canceled her last appointment, or the appointment she had prior to her disappearance. He lied about a number of different things. He lied about the nature of the threats that he reported to the police. What he told the police on September 24th of 2001 is that Michele and Cal indeed had a fight that he overheard, that Cal did indeed threaten her, but that the threat was that she would lose the divorce, wouldn't get any Harris money, wouldn't get the kids, things like that. In that instance, he's talking to the police, they're asking him questions. We brought in Del Giorno, who specifically said, I asked him if there were any threats that he knew of, and he told me yes and reported this threat. There's no other way to put this other than Wyszynski lied. He lied about the nature of the threats. He lied about what he told the police that day, and he lied about the police conduct. The two investigators who went in there, they have no axe to grind. They have nothing to gain or lose. They were on the outskirts of this investigation, asked to do interviews, and went about doing their jobs. They walked in, we want to talk to you, what do you have to say? They took contemporaneous notes about it, were undoubtedly professional, identified themselves, and walked out and reported what they had heard. 4 years later, Wyszynski comes forward to Mulvey, supposedly because she wears a uniform. And we know from McAvoy that that's not true. She never wore a uniform, she was an investigator. Wyszynski's account of this is simply ludicrous. And we know that on September 28th, a few days after he initially spoke to the police, he called them up to give them more information, and the more information he gave them at that point in time was that he knew of some other affair that he thought Cal was having, and he conveyed that to him. It is just incredible to believe that these threats would have been made by Cal, number one, and number two, that Wyszynski would not have reported them to the police at the time that they were asking him about that. He certainly knew from the testimony from Del Giorno and Phillips, walked in, said hello, greeted them, and then took the information down, reported it. 5 minutes, Judge?
You want to take a break now?
If I can.
All right, we'll take a... come back and be ready by 11:50.
11:50?
Here we are.
Take your time to get this. It's coming out right. And this is much more he didn't trust him on that, so I guess it's whenever they can arrange it with the attorneys.
And it gets him, yes.
So the media is origin with the attorneys?
I mean, he didn't say anything one way or the other, so it's not...
We don't know.
Yeah, we don't.
Yes, I am.
Oh my God.